Hello and welcome to the latest legal update from the solicitors group TSG Legal TV. My name is Colin Beaumont. I'm a solicitor in private practice and today I'm going to be discussing some issues which crop up when advising clients in the youth court. Let's start off, if we may, by looking at the importance of age in the youth court. It's not an issue really that troubles us when we're in the adult court, because whether they're 18 or 80, not much really hangs on it. But age really is crucial in the youth court. Remember that the age of criminal responsibility in this country is 10. So that's the age of the youngest person that you're going to see in the youth court. The age range or span is normally no younger than 10, no older than 17, although occasionally, as you know, we do get involved in dealing with 18-year-olds in the youth court. Now, imagine that you attend upon a client on the first hearing in the youth court and he's 18. Now, he was 17 on the commission date of the offence and he was 17 at charge. And so the police have no criticism of the police. The police have quite rightly bailed him to attend the local youth court. The problem is that you notice that he's 18 at the first hearing and he's in the wrong court. Now, I'm not sure what the mechanism is for actually getting him into the adult court. What I don't want is for him to have to go back to the police station and be recharged and rebailed. I'm sure he doesn't want that as well. So I don't really think there's anything improper in the proceedings simply being transferred. No doubt the legal advisor will come up with some authority for saying that the case can be transferred to the adult court, because that's where the case must be. Now, having said that, there's nothing wrong with a 17-year-old becoming 18 in the youth court. But please do bear in mind that if the matter is triable either way, and he or she becomes 18 prior to plea, then you deal with plea before venue mode of trial in the youth court in just the same way that plea before venue mode of trial would have been applicable in the adult court. There's absolutely no need to have the proceedings transferred to the adult court. I'm sure the youth court can deal with it. And even if they're a little concerned, why don't they just reconstitute themselves into an adult court and deal with it? This only applies, of course, where he becomes 18 prior to plea in a matter triable either way. Now, it may be the case that he's become 18 and has now been convicted. And the issue is, where is he going to be sentenced? Well, it seems to me the magistrates have a choice. If you look at the Powers of Criminal Courts Sentencing Act 2000, Section 9, they can either keep him in their court for sentencing purposes, or they could remit him to the adult court for sentencing there. Of course, this wouldn't apply, would it, if they were dealing with a youth for a purely indictable matter, because there is no power at all for the magistrates in the adult court to sentence on an indictable matter. So we are talking here essentially about matters which are triable either way. Now, I'm not sure where you would like your client to be sentenced. There are advantages and disadvantages. Let's just consider the possibility of custody. Now, with custody, the maximum sentence in the youth court is a detention and training order of up to 2 years. And we have case law that says there's nothing wrong with a detention and training order being imposed upon someone who's achieved the age of 18 by the time of sentence. The alternative is that he's remitted or transferred to the adult court for sentencing there. Well, that might be rather beneficial in the sense of, as you know, for one offence triable either way, the maximum custodial sentence in the adult court is 6 months. It's also true, is it not, that in the adult court, it would be a custodial sentence of detention in a young offender institution, which can be suspended, not less than 6 months nor more than 2 years. Of course, there can be no suspension of any custodial sentence in the youth court. Food for thought, really. What about if the magistrates are considering a community penalty? I think in those circumstances, it's probably better that he stayed in the youth court and got a youth rehabilitation order. For one reason, if for no other, that if he were to breach it, their sentencing powers on a breach are so much wider than in the adult court. Remember, on a breach in the youth court, the court could take no action and simply allow the order to continue, or could decide to fine and allow the order to continue. Those options not being available in the adult magistrates court, who must either make the community requirements more onerous on a breach, or revoke and resentence. So there you are. Age, always be alert to age when you're dealing with youths. Where should a youth have their trial? Well, most of the time that's going to be in the youth court, certainly if they're alone in the youth court. Occasionally, a youth might end up having their trial in the adult magistrates court if they're jointly charged with an adult, or they're charged with offences which, although not jointly charged, arise out of the same circumstances as the offences for which an adult is also charged. Now, it may be that on occasion a youth has to be tried in the Crown Court. Now, the view of the Court of Appeal seems to be that we keep youths away from the Crown Court as far as is possible. But there was an interesting case last year, and it's the case of R, open brackets, WA minor, close brackets, v Leeds Crown Court, 2011, EWHC 2326. Now, what happened in this particular case was that both the adult and the youth appeared in the adult magistrates court because they were both jointly charged. The magistrates declined jurisdiction. The magistrates did not sever the youth from the adult at that stage, so they were both committed for trial at the Crown Court. At the Crown Court, the adult pleads guilty. The youth pleaded not guilty. Now, where do you think the youth should be tried? Well, I think most of you are probably saying, well, he should be remitted back to the youth court for trial to take place there. Very sensible suggestion. Unfortunately, the law does not allow it. There is no power whatsoever for a Crown Court judge to remit a matter back to the youth court prior to conviction. So we are in the unfortunate position of the youth having to have a trial alone at the Crown Court. Now, I don't know about you, but I think that is a wholly unsatisfactory state of affairs, and it's something that Parliament really ought to have a look at, because there's a clear gap in the law. I know that on occasion judges have tried to remit back to the youth court, but of course that remittal, strictly speaking in law, can only take place post-conviction, where the duty upon the Crown Court judge is to consider remittal to the youth court for sentencing purposes. Won't apply, will it, if there's yet to be a trial? Well, that's it so far as the age of the youth is concerned. On behalf of myself and the Solicitors Group, thank you for listening to this presentation. We hope that you will keep an eye open for further events on the Solicitors Group Legal TV, and we look forward to you joining us again at some point in the future. This is Colin Beaumont signing off. Thank you.